All right, good morning, good morning, good morning. It is Monday, February 27th, and welcome to all to and actually what I'm excited for, I think it's going to be an enlightening, an amazing session. In fact, I'm going to ask everyone to remember to mute, please, your systems. And I'm just going to do a quick, brief intro. First off, for those of you who are new to our forum, welcome. Thrilled to have you here. Please tell your friends, so long as they're professionals. We're now approaching 12,000 people on the forum. The more people that we have, the stronger our voice becomes and the more we are able to help one another. So that's actually wonderful. Secondly, more importantly, while our forum is private, these videos are public. These videos are posted on a variety of public sessions, including our YouTube channels and websites. So be advised that any questions you ask are being publicly recorded. That is really all that I have by way of an announcement, except I want to also point out that our landlord-tenant forum is having its first video session on March 3rd. We're going to introduce you to the experts that are devoting hours and hours of their time in that forum. I strongly suggest you go. They're some of the best in the business. And if you guys have any dealings with the landlord-tenant board and you want definitive answers as to what's going on, that is for sure the place to attend. So without further ado, I have 2 minutes before I have to turn this over. So let me start with an introduction. Alex came to our attention actually in the best way that a litigator can come to someone's attention, through case law. Alex has actually, through his work with Gardner Roberts, which for those of you who are unaware is a premier firm in the city, has made case law in areas that we care very much about. Alex has previously spoken to us about his efforts to take Chicago Title to task, which is funny because they were our last presenter on this forum, but his efforts to take Chicago Title to task. He was good enough to actually give us a substantive review last time of the title insurance policy and how it actually works and what the title insurance companies are responsible for. I bring that up because unlike other guests that we have that dance around spurious topics or may actually just talk about the law very generally, Alex is known for his detail. And delves into issues that matter. The issue that Alex is planning on delving into now is one that I really feel is a gaping hole in most realtors' knowledge base, that is joint ventures. And that's largely because realtors are never really trained to set up joint ventures. And yet many of us engage in real estate as a joint venture, that is to say, not with our spouse or anything else, but buying it with a friend. And that everything goes right in contracts until it doesn't. The whole purpose behind a contract, a mentor of mine once said, a contract is merely a collection of things that have gone wrong in the past. And it's when it goes wrong that fundamentally understanding what type of relationship you should have engaged in becomes very important. And so rather than actually understanding it retrospectively, Alex is here to help us plan and understand what's available to us prospectively. Again, I can think of no one better to give us his time. And as it's now 10:05, and that is my promised time to zip it, I am turning over to Alex. Alex, thank you very much for joining us. We're looking forward to hearing everything you have to say.
That's great, Mark. Thanks for the introduction there. And just before I get into this, so as sort of Mark alluded to there, really where I come into these situations with my dispute resolution background is sort of looking at the after effects of joint ventures that are set up incorrectly and what goes wrong. And so the way I am approaching this and sort of the way I approach these issues is what should you be doing in advance to set yourself up for success and to avoid the likely strife and heartache that's going to come along with not having set up your joint venture or a client's joint venture properly in the first place. So I'm going to share my screen. I've got a slide deck prepared just to keep us on track. So just bear with me for 1 second and I'll make sure I get this. Okay, so you should be able to see on the screen the slide deck, joint ventures in real estate, what we're talking about today. So in terms of an agenda, we'll quickly talk about what is a joint venture in general terms. we'll flip into important considerations, which includes the main point and the main takeaway that's I think going to come away from today is you need to get your joint venture agreements or relationships in writing. It's going to save a lot of time, cost, energy, heartache in the future. We'll touch somewhat on holding title and the way that title can be held in joint ventures, given that we're talking about joint ventures generally in real estate. And then just some sort of issues with respect to, selling the property, or there's a sort of another potential avenue with these joint ventures that we'll talk about. But things sort of looking at towards the end of the relationship. And then finally, I'll go over some of the pitfalls and issues that can arise if you don't have the joint venture set up properly in the first place. And I've got 3 cases, a couple of older ones and one relatively recently, that just highlight some of the issues that parties face in these situations. So in general, look, what is a joint venture? And, it's on the screen there. You've got an agreement. It's 2 or more parties, can be 5, 10, however many you like, who are combining resources to complete a project or reach a goal. And when I say combining resources, it can be combining funds, combining expertise, combining contacts, a number of different things. From the real estate context, the most common or familiar is going to be buying some sort of property, redeveloping or developing that property, and then ideally selling it for a profit. And that can be in the context of buying an existing property that has a dwelling on it and either tearing it down and rebuilding or renovating the property. Or alternatively, it could be buying raw land and then building, starting from scratch and developing a single home or a subdivision and things like that. Now, just based on my sort of experience in the areas, there's about 3 different junctures that arise where parties often can get into trouble if they don't address them properly at the beginning. And that's, from the very outset of the relationship, when you're identifying and trying to acquire whatever property you're looking to redevelop. The second would be in the middle, when you're actually taking steps to redevelop the property, doing the work, whether it's renovation, construction, or what have you. Paying for expenses is a big one. And then the final aspect is, selling the property or realizing the asset in some capacity, whatever that's going to look like at the end of the joint venture. So, natural first step, of course, is if you're planning to redevelop a property, then you need an actual property. You're going to have these sort of initial discussions, presumably between the partners to the joint venture about, what are we going to buy? What's the goal here? And what are we forecasting the future value to be? But before you even get to that stage, I'm always going to advise clients, you need to take a step back and deal with a number of issues before you even get to that stage, before you put pen to paper, before you identify the property, before you buy the property, because there are issues that come up just from even buying the property that need to be addressed at the outset. There are situations, of course, where somebody already owns a property and they're bringing in partners to help them, or the parties already own the property together for some reason, some prior relationship, which is fine. But again, it's take the step back at the beginning stage before you actually, have boots on the ground, shovels on the ground, whatever you're going to do to redevelop, and deal with these issues up front to save yourself a lot of trouble in the future. So, it's common, and I think probably more common than it should be, that people get together and they have this great idea or opportunity for redevelopment, and they see future potential investment or profit or stars in their eyes of how this is going to work out for them. And on a wink and a handshake, they start, money starts changing hands. They start doing work to the property, but they don't actually have anything in writing. And so what happens, and I've just got some sort of examples on the screen of, what happens when an issue arises that you didn't talk about in the beginning, right? One party says the agreement was X, the other party says the agreement was Y. What happens if one of the parties dies or becomes incapacitated and they can't participate in the joint venture any further? And so you may have dealt with these issues, you may not have, but if they're not in writing and they're just an oral sort of agreement on a handshake, while they can be found enforceable, the difficulty is that the parties and the court, ultimately the court at the end of the day, is going to have to wade through the evidence and what the parties say are the agreements, which they may not agree on, of course, to determine what the terms of that agreement are. Obviously, having an oral agreement doesn't give you anything to turn back to in terms of a document to assist the court or whoever in understanding what the actual relationship was. So the first sort of main point, and it's, I didn't make it as bold as I probably should have, but to make it easiest on yourself, your clients, get it in writing at the beginning. Whatever the agreement's going to be, it doesn't matter. Get it in writing. It gives clarity to the parties, and if you do have a dispute, because disputes potentially still will arise, it gives clarity to the court. It gives certainty to the parties. They understand what their roles are, what their interest is in the joint venture, their potential profits or share of any proceeds. In addition, it provides a path to resolution of disputes. And I think that's probably the most important piece of this, is that, inevitably people go into business together. They're going to get into a dispute over something. It may be minor, it may be major, but if you have a written joint venture agreement put together at the start that addresses a number and as many issues as you can, it's going to give you the best, start you off on your best foot forward to set you on a path of resolving the dispute with hopefully as little cost and as little time expended as necessary. So with respect to a joint venture agreement, I've got a number of points on the screen about things that I think are important to identify. The first sort of one at the top, and I'll just sort of go on these in order, but what's the purpose of the joint venture? Are you buying the property to redevelop and then resell it? Are you buying it to redevelop it and then a party is going to stay behind and lease it? For example, and I'll talk about one of the cases in the pitfall section of this presentation. But parties get together. One party agrees to act as sort of a capital partner, putting in the money and redeveloping, while the other goes in and actually stays at the property and operates the property. And in this case, it was a commercial venture. Well, that needs to be clearly defined at the beginning, because if one party is on the understanding that once it's redeveloped and everything is done, it's going to be sold, and the other's on the understanding that, well, it's not going to be sold, we're going to continue to stay here and lease, right? There's a disagreement and a potential for disagreement when you reach a certain point in the relationship. So at the beginning, you need to identify what the purpose of the joint venture is. Are we, what are we doing with this whole idea? In terms of the structure, individuals are going to join up together. Could be, many individuals, 2 individuals, as I said, as many parties as you want to the joint venture. Or they're going to do it through their corporations, right? You can have much more complex type of structures with holding companies, holding title, construction companies, management companies. But these are things that need to be dealt with at the outset to identify who the actual parties are, especially when it comes to who are the parties who actually have a say in how the joint venture is actually going to be operated. And that sort of flows into the next point, is with respect to the participants, is what are the roles going to be? Are you going to be an operating member, a capital member? Generally, you're going to have sort of some combination of capital members and operating members. Capital members, of course, I think by the usage of the term, they're coming in and they're financing this redevelopment or the joint venture. And that can include, upfront costs for buying a property. It can include ongoing expenses like mortgage expenses or property taxes or carrying costs or construction costs or whatever they are. And then on the other side, you have sort of operating members. Who's actually doing the renovation work? Who's doing the construction work? Who's managing the property while the redevelopment is ongoing? These are things that need to be identified at the beginning, so the parties have an understanding of what their expectations are throughout the life of the joint venture. When it comes to, jump back a sec. When it comes to funding, are these funds that are coming from the parties themselves? Are the parties going to agree to put a mortgage on title to fund construction or whatever other expenses are going to be coming up to the life of the joint venture? So again, things that need to be identified at the outset, because it's nice to be able to put the money in at the outset to buy the properties, but expenses are inevitably going to come up along the way, and expenses that you may not have contemplated. Development charges. Perhaps you have a construction lien registered against the property and you need to litigate it and hire lawyers. Well, who's going to pay for that? So again, you need to identify in a written joint venture agreement what everybody's contribution is going to be to the joint venture and how you're going to deal with ongoing expenses going forward, because otherwise you get into disputes of who's paying for what. Neither party, or however many parties they are, they don't think it's their responsibility. And in the meantime, what's happening is costs are just continuing to accrue, which are at the end of the day eating into what are the potential profits from the redevelopment. And that sort of flows into the next point of responsibility for ongoing liabilities and expenses, is who's paying for things and how much are they expected to contribute throughout the life of the joint venture. Now, when it comes to sale provisions, number of things to consider. Obviously, at the end of the day, if the idea is to redevelop and then to resell the property, okay, well, when are you going to resell it? Is this a 2-year thing, a 5-year thing? I mean, of course, there are going to be variables with respect to construction time, redevelopment time, and the market. But you want to have an idea of the exit plan. You know, what are we working towards? When you're ready to sell, and especially if this is, I know I'm presenting to a number of real estate professionals, if you're a member of the joint venture, is it going to be listed and sold through you and your brokerage? What if you're dealing with other real estate professionals? Are you going to share commissions? Are you going to find a third party to list it? Again, all things that need to be determined up front to avoid disagreements in the future about who's doing what with respect to the joint venture. And then, of course, probably the most important, given the idea for a joint venture is going to be earning profit, is distributing the proceeds. When are proceeds going to be distributed? In what percentage and in what order? Because you're going to have a number of expenses, mortgages, liens, ongoing construction costs that are going to need to be paid out first, which is going to leave a pot of money at the end of the day. And who's going to get paid? Who's going to get paid in priority, if anyone gets priority? And in what percentage sort of breakdown are people going to share in the profits? Now, I've included in the so the last point is just a dispute resolution mechanism, and the reason why I include that is, in general, the parties are able to go to court, right? Ontario Superior Court of Justice, and you can submit your dispute and have a judge decide it. One of the difficulties at the present time, and it seems to be somewhat of a holdover from the COVID pandemic, which continues to plague us, is current motion dates in Toronto, for example, are in early 2024. So even after you get a lawsuit started, getting before a judge is becoming somewhat difficult. So you can include, for example, an arbitration clause in your joint venture agreement. If you have a dispute, you can submit it to arbitration on very tight timelines. There are a number of private arbitrators in the province who will resolve these disputes for you. But again, something to consider, because if you do have a dispute, which, as I say, is probably something that's going to come up in some fashion, you want to have it dealt with on a timely and cost-effective basis. So something to certainly consider when preparing a written joint venture agreement. Now, one thing, and I'll talk about on the next slide, is just dealing with the issue of tax. And as we move forward, so just on the second point of my sort of key considerations, just holding title, and that's personal ownership versus corporate ownership. So there's generally two ways you can hold title. You can hold title in the name of an individual or multiple individuals, or you can hold the title in the name of a corporation, or again, multiple corporations. If you're looking at holding a personal ownership, so could be the individual, one of the individuals in the joint venture. Well, first, I mean, how many joint venture participants are there? If there's two of you, or three or four or five, however many, is just one of the JV participants going to be the single registered owner? Or are you going to have multiple registered owners? Is everybody going to be registered on title? 2 people, 3 people, 4 people, again, however many it is. And if you have multiple people registered on title, well, how are they going to hold title? So, you may be aware there's sort of 2 ways to hold title: tenants in common versus joint owners. Tenants in common, if you have people holding, for example, 50-50, if they pass, or the title devolves to their estate. So in other words, the parties retain their interest as registered on title. So again, if it's a 50-50 situation, if one of the parties dies, the 50% devolves to their estate. If you register as joint owners, well, the interest of one party who dies automatically transfers to the other title holder. So instead of actually going to the estate or to someone else who they designate in a will as their beneficiary, the other joint venture participant gets 100% of title. And once they've got, once that happens, then it's going to be difficult, if not impossible, to change that relationship and to have a court sort of say, no, it was always meant to be that the other joint venture participant, the state, would continue to share in the profits of the development. So something to be dealt with at the beginning. really to understand the consequences of what happens when the, hopefully, an unfortunate situation happens where somebody passes, for example. And I mentioned tax issues because one of the considerations for whether you're registering or holding title personally versus corporate is going to be tax considerations, right? Different tax rates for personal holdings versus corporate holdings. And also with respect to personal, there's an exemption, for example, for the principal residence exemption on tax issues. And I've actually got a case, and just give you a quick anecdote where there were 3 parties who entered into a joint venture. They bought a property, intended to redevelop it and resell it. They only registered title in one name. So one of the 3 actually had title registered in their name. That party, after they redeveloped, lived in the property for a year before the sale. And then after the sale, claimed the principal residence exemption on their CRA filings to be exempt from paying tax on the gain which had accrued. CRA rejected it. They rejected the claim that it was a principal residence, and they assessed tax on the sale, but they only assessed tax against the single registered owner. They didn't address it. They had a joint venture agreement, but they didn't address responsibility for tax because the understanding apparently was that they wouldn't be paying tax because they'd be claiming the principal residence exemption. And now the sole joint venture participant who had title registered in their name and had taxes registered or had taxes assessed against them is fighting to collect from the other 2 joint venture participants who say that it was never their expectation that they would have to pay tax. It's not to say that at the end of the day, they wouldn't be responsible for a 1/3 share. But again, this is a situation where they're in court to fight about this and are relying on the court to make those findings for them. So again, increases time, increased costs, things to be dealt with at the beginning of getting into a relationship of one example, dealing with taxes. So now when you get to corporate ownership, similar sort of tax issues can arise. Although the principal residence exemption is a different story in this context. But if you're going to be, entering into the joint venture and holding title through corporations, are you going to be using an existing corporation? If you're going to be using an existing corporation, well, if it's not your corporation, you want to be concerned about, existing HST liabilities, existing, liens or other sort of amounts payable by this corporation, which you could unknowingly become liable for. If you don't do your sort of background investigations and due diligence on who you're doing business with. Are you incorporating a new corporation? Are you going to have many corporations for different things in the joint venture? And again, it's going to depend on the scope of what you're doing, but for holding title, undertaking construction, or managing the property. And there's one case, the last case I'll talk about today. There's a very complicated structure, 12 years, 400 homes they built, hundreds of millions of dollars. They had a vast web of different corporations that were involved in undertaking all the different roles in the joint venture. Again, some for holding title, some for doing construction, some for management. So again, other things to think about, depending on the scope of what the joint venture you're getting into is whether you need to have more than one corporation. And there's other issues with respect to insulation from liability and things like that you want to be thinking about. And then if you are, again, doing it as a corporation, who are the shareholders going to be? What are their respective shareholdings going to be? 50-50, 66-33, different sort of considerations, and putting into place a shareholders agreement dealing with how the corporation is managed, how disputes are resolved, share sales, and things like that. Now, if you set yourself up correct from the start and you did, what you should do, which is put in the joint venture agreement, shareholders agreements, whatever you need in writing, it's easier to determine how things are going to look going forward when you reach sort of the last stage of the process. And if you're selling the property, realizing all the profits by selling the property, you can define, an orderly discharge of the encumbrances. If you have mortgages on title to get paid out, construction liens can arise. How do they get paid out? Reimbursement of expenses incurred by the participants, right? If you've properly defined who the capital partner in the venture is, or capital partners plural are they going to be paid first before any net proceeds are paid out? How much are they going to get paid? If you've done a proper accounting, you can determine those things without too much argument and without too much strife. Again, the example that I gave earlier, how are you going to satisfy the tax consequences? Who's going to be responsible for paying for the taxes? And when are they going to be paid? And what happens if you've got them registered in, or the property registered just in a single owner's name. And they're assessed for the taxes. Are you going to have some sort of security put up, or funds not being paid out of the lawyer's trust account pending, a redistribution or recalculation of who's entitled to what based on what expenses they're responsible for through the joint venture. And then finally, the idea of distribution of the net proceeds based on your ownership interest in the joint venture. And hopefully you've identified what the respective shares are of the parties and what that's going to look like in terms of who gets what and when. Now, one alternate that I don't think people necessarily speak about or think about as often is, not necessarily, and I mentioned at the beginning, not necessarily selling the property after it's been redeveloped, but one party potentially being involved, or multiple parties potentially being involved after the redevelopment with a view to leasing the property, especially if it's, for example, a commercial property versus a residential property. So what you need to address is, who's going to remain involved? Is there, if there's two parties, is one going to stay on as the landlord? Is one going to stay on as the tenant? Is one going to leave? And if one is going to leave and one is going to continue to lease the property, for example, if the capital partner, they've decided, look, we've made our profits on this, we just want to take our profits, we want to leave. You, operating member, whoever you are, you're going to stay in, lease the property, and continue to operate out of it. Okay, well, how do you value an exit from the capital member, especially when you're not actually exposing the property to the market, right? Are you going to have an appraisal done? Who's going to do the appraisal? What happens if you can't agree on who the appraiser is going to be? So again, all things that need to be addressed at the outset to avoid the issues that are potentially going to arise when these situations inevitably present themselves. So, I'm going to move on to some pitfalls in a moment, but the point is that there's many issues to be addressed up front before you get too deeply invested into the project, before money starts being paid, before again, as I said before, shovels get put into the ground. And this isn't to say that you can't amend the terms of the agreement later on as things progress, or that you can't put in an agreement while or after a joint venture has already sort of started. But remember that it takes two to tango, or at least two to tango. So if you haven't properly defined the relationship at the start, then you're setting yourself up for potential issues and difficulties going forward. Now, from a consequence perspective, is what happens, and what are some examples of things that can happen if you don't adequately address the issues up front? You may not be able to. If the whole point of the joint venture was to sell the property, well, if you don't address the issues, then maybe you can't sell the property, and the capital's tied up. You're continuing to incur expenses. Somebody's going to have to pay for something while the property is, still held and not being sold. And what if the parties can't agree on who's going to pay? So the expenses continue to rack up. You may have lawsuits brought against the joint venture participants. Could be the title holder, could be the whoever contracting parties are involved. And what's happening is you're incurring legal costs, you're incurring other costs, and ultimately it's eating away at the profits which you had theoretically hoped to earn by entering into the joint venture, as the whole sort of point of this at the outset. So a couple of examples, just to sort of explain, and varying examples of informal agreements between a couple of people to some midstream type redevelopments where somebody already owned the property and tried to start up a joint venture after they'd already owned the property. And then the one I mentioned before, the complex sort of joint venture, which involved hundreds of millions of dollars. I'm going to go through a couple of them right now. So, and if any of you use Canly, or you know how to get on Canly, you can look up the cases. I've included the citations at the top of the slides. And so in the Hezzer case, what you had was two parties entering into sort of this informal agreement without a joint venture agreement in writing. And they buy a property that has both a residential component and a commercial component. And the commercial component was horse boarding and riding facility with a number of stalls and a track and things like that. And so the idea was, or so what seemed the idea was, that the parties would buy this property together. One would act as the landlord and like sort of capital partner to the joint venture. The other would act sort of as the operating member and the tenant of the joint venture. There was a sort of dispute over, or there was an agreement that the property did need to be fixed up in some capacity, but a dispute over ultimately who had to actually do the work to bring the property up to a point where it could be sort of capitalized on, whether through a sale or through just ongoing operation of the horse facility as a business. There's a partial written lease agreement between the parties, but it was only signed by one of the parties. They never actually sort of went through with it. And so after the tenant side, the operating member, took possession of the property, they do so believing that the landlord capital member is going to start fixing it up before they have to pay rent or before anything happens. And the relationship breaks down because the landlord partner, capital partner, says, "Well, I bought the property, but I'm not going to actually do the work to it. You're the one using it. You should be doing the work." So they go to court and they fight about this. Both agree that they need to sell, but still had a disagreement over what the rights of the tenant would be after the sale. The tenant continued to say, "Well, look, you sell the property, we want to continue operating it. So you can sell it, but subject to my right to continue leasing the property." They bring a motion for summary judgment before the court, and the court says, "Look, I need to actually see the people. I need to see the people and hear their evidence. I can't decide this on a motion. And so I'm sending your dispute off to trial. I'm not going to decide it right now." They had a trial 2 years later. And in the interim, they're carrying the property. They both own the property. They've got additional years and expense that are sort of accruing over time. And the capital that they had already put into this property was tied up for a couple of years. So the takeaways, again, lack of a written joint venture agreement leads to reliance on the court to settle disputes. You may not get what you actually want. People walk into court every day and half of them come out generally unhappy. You need to deal with the issue of a sale mechanism, including the timing and existence of any remaining rights on the sale. Otherwise, again, you're going to have to ask the court to step in and figure out what the actual agreement was between the parties. And what happens if one of the parties wants to exit the joint venture early? They decide, you know what, this isn't for me. I want to sell. Again, how do you deal with that? How do you value it, and how do you figure out if there's any sort of hanger-on rights for any of the other parties going forward? The Harak case is an example of two parties who enter into a joint venture. One had already sort of owned, he was already owning the property at the time and operating it. It was a mixed commercial residential type property that he'd been operating at a loss and was looking for some sort of assistance to renovate it and then resell it. Now, this case I always sort of refer to because the first line in the judge's reasons from the decision, and I'm going to read it verbatim, is, "This action is a cautionary tale to those who may think they can enter into a business agreement on the strength of a perceived understanding between them and their mutual trust." So really, it's a warning that going forward without having adequately defined the roles and expectations of the parties in writing can lead to a lot of cost and a lot of disagreement. And in fact, in this case, the individuals involved were excellent friends who had their relationships just completely destroyed by what happened. And so in this case, party owns the property, brings in a real estate agent because he wants to sell the property, doesn't get any offers. And so they sort of switch their agreement in terms of what would happen, in that the real estate agent would come in as a partner, would help in renovating the property. They were going to actually add some units to try and make it more marketable and valuable. And in doing that, they're going to renovate and things like that. They actually transfer title from the original owner into the name of the real estate agent. So after they do all the work, again, on a sort of handshake and everything's going well, they sort of get into a disagreement over payment of proceeds at the time of the sale. And, it comes out sort of in the positions being exchanged by the parties that the original owner says, well, no, hang on a minute here. The real estate agent I brought in, he was just registered on title for formality purposes, and he was just a trustee holding it for me. He wasn't entitled to any of the equity from the sale. Whereas the real estate agent says, no, hang on a minute here. I came into this deal specifically for the purposes of redeveloping, to lend my expertise and to lend my knowledge of real estate into what we were doing to make the property more marketable. And I came in with the agreement we'd split the profits equally. And so again, they go to court, significant, lengthy litigation, destroys their friendship. There's no agreement for the court to turn to, and they've got to sort of decide, who do I believe? This he said situation. The court finds one party credible, the court finds the other not credible, and ultimately says, yeah, look, the defendant, the real estate agent who came on title, he was more than just a trustee, and he ultimately got 50% interest in the proceeds. But by that time, a lot of the proceeds had been eaten away through costs, and was held up, of course, for years while the dispute was working its way through the courts. So again, I think I said this once, so I'm going to say it 100 times, is you need a written joint venture agreement to define all the issues between the parties' roles, responsibilities, and expectations. Otherwise, you're relying on the third-party court to decide these things for you, and you may not be happy with how it goes at the end. And it just sort of, as I said there, the point of the written joint venture agreement is really to define adequately who the parties are and what the expectations are. Now, the last case, relatively recently, and this is the one that I was mentioning earlier, where they had, this was a much more complex joint venture, which I find even more remarkable that they didn't have really a written joint venture agreement, because we're talking 12 years, about 7 projects of over 400 homes, and about $165 or $164 million in revenue over that time. They had a bunch of different corporations holding title, some doing construction work, some doing management of properties, some doing advertising, marketing, things like that. And eventually, the relationship deteriorates in the context of one of the 2 parties to the joint venture. So there were 2 individuals who were sort of managing, and they were friends from some time prior. One of them passed away. And they didn't have a sort of mechanism for dealing with what happens if one of the parties to this, multi-million-dollar real estate empire, what happens if one of them dies? And so the estate gets involved, and they get into a sort of disagreement over who's entitled to what and profits. And both sort of point the finger at each other, saying that, look, you've been overpaid. There's been some misappropriation of funds. We can't agree on an accounting or who's entitled to what. Now, there's one thing that they did agree on, was, they were 50-50 partners. But what they hadn't defined was, well, when are you entitled to take money out of the joint venture? When are you entitled to actually receive some of the proceeds of sale, and to, pay yourself back for expenses and things like that? And so both parties go to court, pointing the finger at each other, alleging the other had received millions and millions of dollars more than that they were entitled to. There was a 3-week trial, very contentious, thousands and thousands of documents and many, many witnesses giving evidence. One party is ultimately successful. The court sort of finds that, they both had received sort of overpayments or more than they should have got from the joint venture over time. But after you did the set off, one party was sort of more successful than the other. They had costs awarded against them of $300,000. So they had to pay not only their own lawyers for a 3-week trial, plus the action that they'd been engaging in for the past however many years, but they also had to pay the other side's costs, $300,000. So again, it just sort of brings back the point of, if you don't have a written joint venture agreement, there's going to be situations that are going to come up, or potentially could come up, that could lead to a lot of difficulty, a lot of cost, and a lot of delay if you don't address them at the outset. So I think the key sort of takeaways that I wanted to impart on you today is the first step, and it comes, I think, along with having a written joint venture agreement, is hire a lawyer. Talk to a lawyer, a real estate lawyer, a lawyer who deals with contractual issues, to set you up properly and to give you the advice you need about all the different things you need to think about when entering into a joint venture agreement. It gives you an opportunity to sit down with the partners, to understand what your goals are, and even gives you sort of that ability to say, like, are we aligned? Are my partners in this joint venture, are we aligned on what we want to do through this joint venture? You should also, and I would suggest, not only a real estate lawyer and a lawyer with experience in contractual matters, but also speaking to a tax lawyer, understand the benefits and consequences of how you propose to enter into the joint venture, whether as individual parties or through corporations, because there are different tax consequences. I'm not a tax lawyer, but I know there are different tax consequences that are going to arise depending on which of the two sort of different options you decide, whether to register and proceed as an individual, or whether to register and proceed as a corporation. And then again, you need to have a written joint venture agreement in place to deal with who's holding title, how are you holding title, what's the structure and purpose of the joint venture, what are the parties' respective roles in the joint venture, how are you paying for expenses, and how do you address things like a sale, somebody wants to exit early, somebody dies or becomes incapacitated, all things that are potentially going to come up through the course of the joint venture that if you don't deal with is going to probably lead to litigation, in which case you're looking at a significant amount of time and a significant amount of expense trying to sort through all the various issues that have arisen. And with that, I think we're almost exactly where Mark wanted to end, around 10:45. And so I'm happy to answer some questions and to hear any comments. And I'm just going to stop the share.
Thank you, Alex. Alex, I'm going to ask we're going to get to Bass in 1 second, but I'm going to ask you the big question. When we are dealing with our client, by the way, you should keep on your screen, you should keep your contact details up. This is your opportunity to advertise. Come on. But the big question I have for you is, when we're speaking to our clients and trying to advise them as to the benefits of a joint venture, now that we understand that, what can we say their expected cost is of going through and drafting a contract on average?
Well, it's a great question, and I'm going to give you the most lordly answer I can give, which is it depends. And really, it depends because what's the structure you're looking to put together? If you're looking to put together a simple two parties, we're going to buy a property, whether it's raw land or an existing existing property that we're going to demolish or renovate and then rebuild. I'd say probably looking at something between $5,000 and $10,000, but it could be more. It depends on who the lawyer is you hire. But it's going to save you, I'm going to say, quite a few thousands and tens of thousands of dollars more if it addresses and should address the issues which you need to be thinking about at the beginning. Now, if you're getting into joint ventures where you're buying multi-acre parcels of land with a view to putting together a 50 home or 100 home subdivision, you're probably going to have a more complicated structure, and cost is going to depend on a number of things, of course. But I think if you're sort of budgeting for a rather simple-ish, and I don't know if there is, and I think simple and joint venture may be oxymorons, somewhere in the range of $5,000 to $10,000 is probably a good estimate of what you're going to need. And again, plus or minus, depending on some specific things that you want to deal with.
Amazing. Bass, why don't we turn to you? Go ahead. Anyone who has a question, please raise your hand. You can do so, just FYI. Well, anyways, I'll explain afterwards, but Bass, go ahead.
Mark, thanks a lot. And Alex, thank you for the presentation. I wish I had seen this 5 or 6 years ago. So I'm basically the type of person you just described. I went through this entire meat grinder on a multi-million-dollar joint venture. And my question for you is, I guess the details don't matter, but we had hired a fancy Bay Street firm to set up our real estate deal. And in the end, when the issues arose, we found out that we didn't have a conflict resolution tool. We had arbitration, that was it. So my question for you is, in these situations, what I learned from this whole thing is that we should have had a shotgun clause. And I want to know, is that the only thing that's available? And what do you usually see as a resolution tool that we have that doesn't mean we have to go to arbitration or mediation?
Yeah, that's a good question. Look, shotgun clause is obviously one thing that you can include. And there's a number of other sort of buy, sell type rights that you can add into a contract. Things like, look, party gives notice that they want to get out of the deal. And the other party just sort of have to accept, look, okay, we want out, we're giving you notice. You've got X amount of days to let us out, subject to, valuing however much the joint venture is worth at the time. and sort of how you're going to pay for that. So if you address it at the beginning, I wouldn't just sort of shotgun provision obviously is a sort of named term and comes with sort of some type of consequences in terms of how you how you require people to deal with a sale of things like that. But I think you can sort of structure it in a way of what everyone's comfortable with, knowing that okay, hey, if we may want to exit this early, and so putting in some sort of contract or agreement terms of, if I want out early, this is the process I need to go through. I need to give notice. The parties need to do evaluation, and then the parties need to go and get the financing or to buy out my interest based on whatever the cost is going to be. And if you include the terms that sort of make it a look, steps 1, 2, 3, 4, give me the money. Not to say that it's not going to still lead to problems, because parties may disagree on the interpretation of those provisions, in which case you're either into an arbitration or you're again going to the court and saying, look, they had to buy me out and we agreed on the valuation and now they're not paying for whatever reason. So I don't know if there's necessarily going to be always a provision that you're going to have available to completely avoid needing to go through a dispute resolution process. It may just happen because parties, they can act in certain ways that you're not expecting when money is an issue.
Okay, makes sense. Thank you.
Thanks for the question.
All right. Anyone else have a question? Just raise your hand. The way you raise your, I forget how to raise your hand. I'm pausing. I think it's under reactions, if I'm not mistaken. There's a little arrow. And you can put your hand up and ask Alex a question. Anyone's welcome. Or given that we don't have any hands up right now, feel free to just unmute yourself and ask.
I must have answered everything in the presentation.
Well, you know what? If nobody else is going to take the chance, I'll ask some more questions just because this is still fresh. And I think it took like 10 years off my life expectancy at the very least. But when it comes to arbitration, I guess for me, the hard part is that it seems to me that we, like in a position like this, there has to be some sort of a dispute resolution tool where you avoid arbitration, because to me, it seems that arbitration is a very muddy way of resolving these disputes. And this is why I've been thinking about this in terms of like, how do people deal with this? Because I can't, going forward, I cannot accept arbitration being my only tool going down the path. But maybe that just requires more due diligence up front to make a contract very clear, responsibility-wise, who does what. So maybe that's what I was missing originally.
Yeah, and look, and you can make the contract as clear as you want, but the reality is that if somebody's going to dispute your interpretation and say like, oh, it's clear, but it's not clear, and here's why, then you're still on the path to needing a third party to deal with it for you. So you can include, and I've got a case right now where the issue with respect to valuation is really sort of what's the only thing an issue, and the parties just have a look. If we can't agree, everybody's going to go back and they're going to get an appraiser who's going to put what the value of the joint venture is and what everyone's interest is worth. And if we can't agree, then those two appraisers that we've got are going to appoint a third appraiser, and that third appraiser's decision is going to be final. But again, you can still see situations where people say, oh well, we can't agree on the method or the manner of how the valuation is going to be done, in which case we need to go to court, we need to go to arbitration. Somebody somewhere is probably always going to find a reason to try and dispute something, especially if it's in their interest for the funds not to be paid out, or for the funds to be tied up for some reason. So really, your sort of ultimate last resort again becomes an arbitration or Superior Court of Justice. And really the two sort of things you need to weigh in the competing issues are arbitrations can be done quickly, but they cost a lot more money because you're paying the arbitrator, you're paying, and you're paying your lawyers. In the court, there are costs like filing your statement of claim and filing for motions and things. It's relatively much more economical than an arbitration, but it's a time problem because it's going to take you have to go through all these different steps, pre-trial procedures of discoveries and exchanging productions, dealing with procedural motions, and then also waiting for the court to give you an available date on when they can actually hear whatever your dispute is. So I don't think there's a perfect solution. I think you can deal with a number of things and include a number of things in the contracts to try and make it as clear as possible. But I don't think you can ever rule out the possibility that you just may not agree. Which, look, lawyers don't like uncertainty, and they try to make it as certain as possible and include as many terms as possible. But I think, Vas, from your own firsthand experience, you may have covered things off thinking that they were covered, and it turns out there's still a sliver of daylight for somebody to dispute that requires you to go to an arbitration or to court.
Yeah, I did not realize the context in which these contracts exist. So basically, I like you said, I thought it was clear cut, but I will tell you how it ended up being, how it was resolved. So like you said, it came down to valuation, and at the end, between the partners, the capital partners internally, we had an outside third-party offer. We had multiple, and then eventually that was what was the baseline that was set, and that's how we basically arrived at the internal valuation of somebody ended up buying out the other party, and that's how we resolved it. But getting to that valuation took a good 12 to 18 months.
Right.
Yeah.
I hope you don't mind. I'm going to ask one question, Alex.
Sure.
When people come to me, I'd say once a month, basically talking about a relationship that is no longer working. And of course, there is no joint venture project or contract that exists. One of the first things that I often suggest to them, and I'm asking whether or not this is actually good advice, and I'm doing so on a public forum, so maybe I shouldn't actually be doing that and we should take it offline, but I'm going to ask it anyways. One of the first things I do is say, before you go to a lawyer or anything else, is there a possibility of introducing a shotgun agreement to you guys? Because usually what it is there's some mechanism of disagreement where valuations are being disputed or anything else. And so what I try to encourage people to do who are at odds but are perhaps not yet at each other's throat is to then sign a shotgun agreement. For those of you who are unfamiliar with what that is, what it is it's an agreement where one party basically says, where both parties say, we agree to the following framework, and one party says, if I offer you something and you would reject it, then you have to buy me out on the exact same terms. That has the effect of making sure that any offer that is proffered is fair. And once an offer is proffered, it will definitely end the relationship because of the mechanism that is then in place. So what I often try to get people to do is put in place a shotgun agreement as between themselves when they are in disputes, such that, because usually the matter of the dispute is this person's acting unfairly. And when that is the case, having a contract even extended at the point of dispute sometimes works. Have you ever seen that functional? Do you ever practice in that space? Maybe this is an unfair question, but I am curious about that.
Yeah, no, I see the wisdom behind it, certainly, because it certainly can save a lot of the troubles which can arise. I suppose the difficulties, and I'm thinking this from the litigator, putting my litigator's hat on, is, if one of the parties is sort of putting that agreement to the other, and the other party signs it, well, what they may say later on, if you get down that path and the shotgun clause is activated, they say, well, you know what, I actually didn't really understand it. I didn't get independent legal advice. I don't really know, I didn't, the party sort of represented to me, this is what it said, and they did it quickly, and we were in a dispute. And not to say that all these things would necessarily carry the day and that a court would believe that position or accept that position. But it can just lead to further conflict in terms of, having to deal with parties alleging, non-est factum or contra profferentum, something, some sort of legal doctrine of, I don't understand it. But from a practical perspective, I get it, provided you sort of set it up in the proper way. And also, theoretically offering it on a, look, this is a sort of without prejudice to our position if we ultimately go down the path of a dispute, because I don't want you using it against me that I tried to offer like a shotgun in the future or something like that.
And have you ever, I guess what I'm asking, I would never do it without legal advice at the point where the parties are in dispute. But I guess what I'm asking is, do lawyers regularly try to put in place some form of self-help corrective means like this prior to engaging in the arbitration litigation process?
Yeah, look, I think so. And I think I've seen it in various contexts. I can't think of specific examples, but it makes sense. I mean, at the end of the day, you're going to, advise your clients that, hey, if you're going to go down the path of fighting, and litigating as either arbitration or through court, it's going to cost you a lot of money. It's going to take a lot of time. So, there's no harm in trying to sort of resolve the matter in advance and trying to, head off the dispute at the pass with some sort of provisions that, the parties can live with. Again, not to say that they would necessarily agree. You may put it to them, but they don't agree with the shotgun for whatever reason. But I don't see much difficulty in actually trying to do that as a way to avoiding, future headaches and more costs being incurred.
Very good. Thank you very much, Alex. Alex, I'm going to turn last question on the forum, and then we'll call it. Jerome has written a question. I think I can. Okay. Well, he said, let's say getting a JV on a purchase of a residential property, but per recommendation of mortgage lender, it has to be joint tenancy. Can two parties still go for tenancy in common, put in paper after closing? Jerome, I think just so that you're aware, first of all, if it's a mortgage commitment to have joint tenants, I'm going to answer this because this is more my bailiwick than Alex's. If it is a mortgage commitment to have joint tenancy, which happens very rarely amongst the lenders, a lawyer can, in every instance that I've seen, push back on it, and the lender will back down on that and will allow for tenancy in common. Lenders never make a big deal as to whether or not you want joint tenancy or tenancy in common. So that's not an issue really for Alex. That's just more for a conveyance lawyer, and your conveyance lawyers should be pushing back on the bank when they make that stupid demand. Once in a while I see it, they always back down. So I hope that answers, and we can turn that away from Alex. Alex, I just want to thank you. You have, as always, been filled with detailed knowledge, which is really what I care the most about when we throw these things together. Guys, I'm going to encourage you to use professionals like Alex when you are doing your work. You can see there's a quantifiable difference between someone who has been in the trenches and those people who have not. And those who have been in the trenches not only understand the law, but they understand how possible it is to invoke rights under the law and when you need to fight, when you don't need to fight. Alex has proven himself a friend of our forum. Alex has proven himself a brilliant legal mind. And the fact that he chooses to spend time with us once a year or whenever it is that we are able to convince him to come by is something that we are all immensely grateful for. And so, Alex, thank you. Thank you for your time. Thank you for your knowledge. And guys, please do use his contact when you are next looking for your joint venture to save yourself the grief of finding your way into Alex's next case law.
Thank you, Mark, and thanks for having me. It was a pleasure.
My best. Everyone, thank you. We will post this within an hour.